What are the arguments in favor? What are those arguments which saying that no, we have the power, we have the constitutional morality to claim our rights? So I will start with first, issue. The issue was that judiciary is interfering in the state domain. But if you say separation of power versus judicial activism. Mr. Chandrachud said that they are not against each other. In fact, judicial interference or judicial activism give direction to the separation of power. They tell legislature, this is your duty, this is our duty, this is executive's duty. Right now you are saying that we are coming into your domain. We are not against anything. We are in the nations to make this nation better. There are cases where Supreme Court usually don't interfere. Like this is the marriage is one of the example. If you see the triple talaq case also, Supreme Court told center, transgender case also, Supreme Court told center, you have to come with the law, you have to come with this kind of system or structure. And they are saying marriage is something is not like this which you can't change at all. They have changed the marriage. In the past, they have changed the marriage. Kahan par? They have changed the marriage when they talk about the sati system. They have changed the marriage institution when they have made the changes in the Child Marriage Act. They have changed the marriage when they have, Supreme Court recently have lot of judgment where they have given the inheritance power or inheritance right to the daughters as well. So there are a lot of incidents where Supreme Court has came but only to save their fundamental rights but not to build any new law. Here Supreme Court is saying you have to build a new law. So all the judgments will understand where they have the rights or not. The first thing, as I told you in the starting only, the constitutional right of an individual of the queer community starts with this Navtej Singh Johar case only. You know why? Because Navtej Singh Johar case not only decriminalized the homosexuality but invoked 3 major actions towards the center and people as well. What are the 3 major arguments or right, you can say right, which derive from that judgment, which actually recognized by Chandrachud itself? The first thing is recognize love and companionship. By decriminalizing the homosexuality, we recognize the love and companionship. Then protection from discriminatory action. Protection from discrimination or discriminatory action. Third one, responsibility of the state government to safeguard their rights. So these 3 things itself saying that you have the right to love and companionship. State will protect you. People will not discriminate from you. Then how will I able to recognize the love when I don't have the epitome of recognition of love, which is a marriage? I am not saying that this is the only way to show the love. But from the societal point of view, this is how we show. This is how we tell. And this is some of the homosexuals don't want you to get married. But if I want you to get married, then why not us? This is their saying. Next important thing is done. Right to live with dignity and goal of the constitutional. We'll understand here the major part of constitutionalism. Now you will say, what is this constitutionalism? Let's understand this. When in the DPSP, you came with this 47 and 38, where you are saying that we will protect the individual dignity, okay? Or you will say that we will able to make sure you are economically or socially, you will be recognized and you will not be discriminated, and this is a state duty to have the dignity life. So how can I have the dignified life when you are not protecting my right to get married? Again, it is not fundamental right. You can say state has the exception to it. But I want to have the fully recognition of my rights. Then how you are not giving us this right? Another main aim of the constitutionalism, if you go for the constitutionalism, we have these three major: social constitution, social contract theory, talked about, which is the, basically if you see, it is the basis of classic liberalism and constitutionalism. This theory is a basis of John Locke. John Locke say there are three things which have the integration of natural rights, which have three things like life, your liberty, and then you have your property. These three things comprise of the natural right, and these things, liberty only in Article 21, which later on in the case of Supreme Court 1984 case, Frankie Corelli case, where Supreme Court has told that Supreme Court told one has the right to express themselves in diverse form, as well as mixing and mingling with the fellow human being. Nature, which is Article 19E. Let's start with Article 19. So Article 19E is talking about right to settle anywhere in the country, subjected to some exceptions. If I want to settle, not to have a house, I need a partner. I need to have that family. If you are not letting me to build a family, how I able to recognize this law? Very valid. Article 21, as I already told you, the dignified life, as well as the privacy of their sexual orientation, and right to life, which cannot be saying dignified if I'm not realizing my other components of the society. And Article 15, which is saying that you can marry, you can't be discriminated based on your caste, sex, race, and religion. So this is the 4 parameters. On that basis, you will find the Special Marriage Act is built. Special Marriage Act recognize caste, race, religion, but why not sex? And here, in Puttasammy case, it can be sex can be inferred from that sexual orientation as well. So they are saying, if you have already these laws, why can't us enjoy these laws? And you know, when they are saying that you have the right to marry, so you know what the arguments against was it will lead to polygamy, polyandry, incestuous kind of marriage, where might be daughter or some, in a family you start getting married together. But then Supreme Court said we have these 4 parameters now. We have these 4 parameters to decide. But your argument is against this sex only. Okay. Then right of transgender to marry. Now here we have the debate of difference between sex, gender and sexual orientation. Understand first, What is sex? What is sex? Sex basically what you are biological, you have been given by birth, and that you recognize that thing. It is called simply a sex by looking your biological organs. Then what is gender? Gender is what I perceive. It is not about what my sexual orientation is. For example, why we call transgenders? Because they have some different kind of sexual biological sex organs, but they have a different kind of feelings or attitude or behavior other than opposite to their sexual identity. And that's why they have then we call it transgenders, because gender is what you recognize irrespective of your biological or sexual orientation. And then we have sexual orientation, which is a totally different meaning, which is a totally my attraction towards somebody else, my sexual willingness towards somebody else. So here come, when we talk about the transgender, they are saying you are giving the rights to the transgender to get married. And even Tushar Mehta, who was arguing against, and from the side of center arguing against the community, said basically that in transgenders we have trans men and trans women. They can marry. Then we have trans women and cis men, basically normal men, trans women. Then we have trans women can marry cis men, trans men can marry cis women, trans women versus trans women can marry trans men, but cannot marry trans women and trans women. This is what they have argued. कि आप ट्रांस वुमेन, आपको दो एक जेंडर डिफाइन करने पड़ेंगे. आपको वाइफ और हस्बैंड, एक को वाइफ का दर्जा देना पड़ेगा, एक को हस्बैंड का दर्जा देना पड़ेगा. एक को आप दोनों को मिला के आप स्पाउस का दर्जा देना पड़ेगा, एक को मैन का दर्जा देना पड़ेगा, एक को वुमेन का दर्जा देना पड़ेगा. बट होमोसेक्सुअलिटी में वो दर्जा हम नहीं दे सकते, तो हम इस मैरिज को हम लीगलाइज नहीं कर सकते. व्हाट दे हैव आर्ग्यूड. बट ऑल दिस आर्ग्यूमेंट कैन नॉट डिनाई that like a transgenders, they also have their some kind of sexual orientation. And you can't, if you have recognized their rights, why not ours? This is their argument. And irrespective of, you are not considering these rights, constitutionalism, you are not considering the Navteet Singh Johar case, then what is the point? Then we have Universal Declaration of Human Rights. India, have borrowed or inspired from the principle of natural rights or human rights. And under human rights, having the marriage is also one kind of human natural rights. Then if you are denying another person the natural right, then you are not adherence to this Universal Declaration of Human Rights. Then how can you say that we are giving you the full natural rights? How can it say it's a fundamental in nature? No, we can't say this. So this is also wrong that you are going against it. The principle of utility. Very, very, very nicely, when we talked about the principle of utility, we talked about the great happiness principle. When we talk about and then here we talk about the society versus individual. And we talk about the greatest happiness principle. Now, how come this utility principle, which is the basis of our most of the laws, is actually depreciating or telling that Benethin said social community is a fictitious body. It is useless without an individual interference. And if you are not giving the individual right, then community, how can you are protecting the community? If you are not respecting the right of individual, how can community will able to survive? You are not giving the greatest happiness for all. It asserts that the only morally right and proper goal of an action is to achieve greatest happiness of all individual whose interest is affected by action. So it's a state responsibility to do such kind of action that individual rights will be able to recognize, so will able to ensure the greatest happiness of all. And then in the last, we all know and we always give that USA, Australia, South Africa, around 36 countries have accepted this, and why not us? And we call us the oldest democracy. A democracy is led by demo, basically the people. If you are not recognizing your own people, how can you claim this biggest statement of oldest democracy? So this makes very important, and this has make a point for them as well. As well, there's one more thing I wanted to add here: adoption right. According to the adoption right, you are under the Justice Juvenile Case Act, you have recognized that two people can come together and adopt a child. But in Adoption Regulation Act, you separately ask for the spouse. Even single woman, single men can adopt a child, but why not these rights given to the homosexuals? Because might be they go under JJ Act. I want to adopt, but recently lot of circulation came by the authorities of child protection authorities saying that we have to consider adoption rule first. Plus, they told that the child should have the parent should have minimum of 2 years of relationships. So here they call the parents, where they want spouse to become together, where we have a husband and wife. And why not us? They are asking. So this is along with this, they have told the SME, which is the Special Marriage Act, which is ultra virus in nature, which I have already explained. Now, what are the argument? Let's read this also. The gender of a person is not same as its sexuality. I have explained you. Choosing a life partner is an integral part of choosing one's own course of life, which is a part of Article 21. Now, what is the argument against? They are saying, let's say marriage is permitted and they adopted a child. Then someone dies, father and mother is LGBT couple. Who will be treated as father and who will be treated as mother? This is their main opponent. First, they are saying, I've already explained this point, that they are saying you are judicially, they are saying you are interfering with the state law. Even in case of USA, judiciary supreme, but in case of India, both have the same powers. So there the laws can be repealed by the Supreme Court, but here you need a court or basically the legislature to come into the action and make this new laws. And you can't just replace us and give us these instructions. This is what the state center is saying. Then again they are saying marriage is a public sphere. They are saying by decriminalizing as I told you in Navtej Johar Singh case, they are saying you have this love and companion, all such things. They are saying what they have argumented against it. They are saying in Navtej Johar case, we told the decriminalization of homosexuality is fine. This is for the private sphere, but marriage is a public sphere. We have not interpreted that you will come into our marriage sphere, which is a more in public in nature. And they have not recognizing this marriage as a public sphere for the homosexuals. They say this will create the social instability. The social structure will get diluted and majorly impacted by this. Simple. Next thing, as I told you, they are saying today if you are legalizing the homosexuality, tomorrow people ask for polyandrous, polygamous relationships. How will we be able to tackle? And the Supreme Court told about this 4 ways to test the marriage, which is caste, other than the caste, race, sex, religion, you can do this. Okay, so if in such case come, they can do this after that. And right to marry is a fundamental right. They are saying in the constitution there is no mention of right to marry is a fundamental right. Then how can you asking this? It is not a fundamental right, because if it is a fundamental right, how can we able to change the child marriage act? So anybody will go. It is actually conferred by the religion. So it is not a fundamental right. People will ask, different kind of marriage will happen. This is not our prerogative to make it a fundamental right, because it is not made by us. It is, marriage is before the state come. They are saying marriage तो इतनी पुरानी है, स्टेट तो अभी आया है, कुछ सालों में ही डेमोक्रेसी वर्ड 200 सालों का, और मैरिज तो हजारों सालों से चलती आ रही है. तो मैरिज जैसा इंस्टीट्यूशन हमसे भी पुराना है, तो हम उसको कैसे अमेंड कर सकते हैं? Then they are saying all the articles which you are saying, article even 15, 19E or 21 is not absolute in nature. Simple. State have the, as per the state interest, social state find it, then they can do it. They can interfere your laws. They don't want you to give you. Then you can't ask for this marriage as a right. And then they are saying, and this typical thing came very strangely. They are told that this asking for the legalization of same-sex marriage is basically from the urban concept. In the गांव देहात they don't want, उनको कुछ नहीं चाहिए. ये सारा urban concept है. ये कुछ elite लोगों को, urban elite लोगों को ये चाहिए. ये सबको नहीं चाहिए. उनके लिए काफी है जिनको homosexuality में उनको दिक्कत है, उनको और ज्यादा राइट, उनको गवर्नमेंट से बाहर जाना है, उनको गवर्नमेंट के कोई रेगुलेशन चाहिए ही नहीं. एंड दे आर फ्रॉम अर्बन पीपल ओनली. एंड देन सुप्रीम कोर्ट सेड, कैसे अर्बन में सब तो अमीर नहीं है, सब तो इलाइट नहीं है. दे आर पीपल हु आर फ्रॉम मिडिल क्लास. यू कैन नॉट से दोज हु आर लिविंग इन अर्बन हैव नो ऑल द राइट्स, दे हैव वेरी गुड लिविंग स्टैंडर्ड. नो, दे आर पीपल हु आर सब स्टैंडर्ड इन नेचर. एंड हाउ कैन यू टेक ऑल ऑफ देम इनटू वन बास्केट? And then they say, what their last argument is, child upbringing. According to the reports, there are reports given by the Aishwarya Bhatt in the Supreme Court judgment. They are saying that there are 3 reports. One is performance of children. It is not been tested in India. It is basically tested in Netherlands, America. They are from American society reports. So, so we have this performance of child in their schools. So they find those who are from the homosexuals and those who are from parents are homosexual, they have less grades than those who are from not homosexual. Then saying the people who have ADHD, hyperactivity disorder, those are more children from the homosexual background and not for the. So they are saying no. Yeah. So this is not the case. This does not happen all the time. There are cases where they are saying this does not happen all the time. There are only few incidents which they find in this report, which is they are saying the child upbringing is not in correlation with the homosexuality. So these are the things. Plus they are saying that if we are going against the Article 14, so we have this intelligentsia differentia. What is this? they are saying we are differentiating on the basis of, this is an exception to the Article 14. They are saying intelligible differentia, sorry. They are saying that for having the stable marriage, you should have the two sex together, two different sex together. So on that rational basis, we have excluded the homosexuals. And they are. It is not like all the countries have accepted this. Italy is saying that we should bar some of the rights given to the homosexuals now. Uganda also has criminalized the homosexuality even. So not all the countries, but no, even though they are not the democratic countries, but still they are countries who is not like Middle East countries, or we do not have any compulsion to, have our rules bind with them only. Okay, so they are the arguments against it. So this is what we have discussed in this today class, the arguments against and arguments for the judgment. And here you will find a lot of social and constitutional issues together, which have made this topic very important. Now, in the last, I just give you one question. The discrimination faced by LGBTQI in the various form is a product of social morality as well as product of lack of effort from a state to sensitize the general public. Comment. I request you to please write an answer on this question and send it to me. I will definitely check and give my feedback. Thank you so much.